I just want to begin welcoming everyone on behalf of Vitruvian Leadership. So glad that we could host this. So far, we're on our third speaker for this for our series of 8. I also want to thank Para for co-hosting today. And I would be absolutely remiss if I didn't thank Dr. Moore. Back in December, she asked me to please make an effort to find somebody to speak about VAWA. And Dr. Moore, who's with the Allegheny County Housing Authority, asked me to do that search. And because of her, she was the catalyst for today's speaker, K Walz. Kate is a senior staff attorney at National Housing Law Project. She's a national expert on federally assisted housing prevention, fair housing, crime-free and nuance property ordinances, and the Violence Against Women's Act, as well as the intersection of the criminal legal system and housing access. And I did send her bio out, and it's pretty impressive, I must say. Prior to joining NHLP, Kate was at the Shriver Center of Poverty Law for almost 20 years, leading the center's advocacy and litigation efforts, including its housing advocacy. We're truly honored, and I am absolutely excited to have Kate join us this afternoon to share her expertise and her knowledge regarding VAWA. And with that being said, I'm going to give her, so welcome, Kate, thank you. And I'm going to give you hosting capabilities here. So you're officially the host.
Okay, thank you. Can everybody see my screen? Okay. Thank you so much for having me today. Thank you, Brian, for reaching out. As Brian said, I'm Kate Walz. I'm at the National Housing Law Project. The Law Project is based in San Francisco, California, but we're a national organization with staff all over the country. I am typically based in Chicago, Illinois, but I'm presenting to you today from beautiful Northern California as we do our staff retreat. NHLP's mission is to advance housing justice for underserved people and communities. And for over 10 years, we've been funded by the Department of Justice on the Violence Against Women Act to provide technical assistance on the housing protections under VAWA. And we've worked with thousands of advocates and housing providers on compliance and implementation issues, really since the start of the housing provisions in VAWA. So that goes all the way back to 2005. We're also part of the reauthorization drafting team for the housing provisions. So in addition to talking about primarily about VAWA 2013, I will give you the VAWA 2022 updates that will go into effect in October of this year. And some sense of when you should be able to anticipate regulations on some of those new sections, because we do have, for the first time, that the federal agencies are actually subject to turning in and producing those regulations within a set time period. If possible, I'd like to save questions until the end, just so that we can get through the content. So discriminatory housing practices by landlords, discriminatory housing practices by landlords can have a huge impact on survivors and can greatly contribute to housing barriers and often force them to choose between homelessness and staying with an abusive partner. In HUD's VAWA final rule in 2016, they talked about the intersections of harm that survivors of violence experience, in particular domestic violence survivors. They often have negative economic and criminal consequences as a result of being a survivor. The perpetrator, as part of the cycle of power and control, will take out credit cards in their name, will ruin their credit history, will intentionally cause damage to property so that their ability to stay housed is threatened because the landlord may use that property damage as a basis to evict. The survivor then has this poor rental history. I have represented hundreds of survivors. A very common tactic of perpetrators is to not let the survivor pay rent, even when they have the resources to do so, because they know then that they are making this victim highly vulnerable and continue to be under their control for that reason. The perpetrator may also force a survivor to participate in criminal activity, or the survivor may be arrested as part of policies that require the arresting of both parties in a domestic disturbance until the police or courts are able to determine who is the primary aggressor. It's also true that perpetrators exploit the criminal legal system and will use that and orders of protection to arrest the survivor, to get an order of protection against the survivor, to essentially use that system against them. The final rule recognizes all of that to ensure that covered housing providers, including PHAs, do not deny a tenancy or occupancy solely based on what HUD calls these adverse factors that are really a direct result of being a survivor. So a very broad overview of VAWA. It provides housing protections for survivors of domestic violence, sexual assault, dating violence, and stalking who are applying for or living in federally assisted housing. The law applies to a survivor, whether actual or perceived, regardless of sex, gender identity, sexual orientation, disability, or age. It was first adopted in 2005, expanded in 2013, and then the 2022 reauthorization, as I said, will go into effect in October of this year, though the money is currently out. And so some of you may actually already be looking at that, such as the transitional housing grant programs. VAWA does not apply to market rate rental housing unless there's some sort of a federal subsidy, such as a voucher. So what are the programs that are covered? Here's the list: public housing, Section 8 vouchers, all forms of vouchers. So this includes the new pots of vouchers that we've seen from the Congress, such as incremental vouchers and emergency housing vouchers, project-based Section 8, which includes the RAD program, Section 202 and 811, the Section 236 program, 221D3 and D5, the HOME program, the HOPWA program, and the McKinney-Vento homeless assistance programs. It also applies to the Rural Development Program. As a result of VAWA 2022, the RD voucher program is covered for the first time, and the low-income housing tax credit program is covered. I think it goes without saying, HUD has done the most in terms of implementation and will continue to lead in that way. And I'll talk about that, how we see that playing out with VAWA 2022. The Treasury has issued no guidance. So that really leaves low-income housing tax credit owners, many of you may interact with because of the voucher program, without any guidance from the Treasury. We are hopeful that is forthcoming in the next 2 years. USDA has issued some guidance. We are anticipating that they're going to be issuing regulations and a guidebook specifically on VAWA and the RD programs. Under VAWA 2022, we now added catch-all language so that any future federal housing program that is providing affordable housing will be covered by VAWA without having to continually go back and amend. So what are a survivor's rights under VAWA? You cannot be denied admission, be evicted, or have your assistance terminated because of the violence committed against you. You must get a notice of housing rights under VAWA. That notice obligation primarily falls on PHAs. You can request that an abuser be removed from the lease and housing where allowed under state and local law or potentially federal law. You must be given time to establish eligibility for the housing program that you're in. This is in recognition of the fact that another part of the cycle of abuse is that a perpetrator will not allow their victim to be added to the household or lease. So they're technically in the home illegally, right, as an unauthorized occupant or guest. But then the recognition by HUD and VAWA is if the perpetrator is removed because of the abuse, that victim should be given a chance to establish eligibility for the program. And then survivors with Section 8 housing choice vouchers can move with continued assistance, even if they're moving prior to giving notice and getting permission from the PHA, if they're doing so as a result of the violence. So who is protected? As I said, it's covering domestic violence, dating violence, sexual assault, and stalking. Domestic violence under the current definition is a felony or misdemeanor crime of violence. So it can be somewhat limiting in terms of what we understand to be domestic violence and how it typically initiates, which is a form of control and emotional abuse. But it's important as a housing provider to take a broad perspective on this and not try to exclude people. So for example, many survivors of domestic violence who don't currently have been experiencing violence that meets the standard of felony or misdemeanor crime of violence do actually fit within the definition of stalking, because it is conduct directed towards a specific person that would cause a reasonable person to fear for their safety or suffer substantial distress. I worked with a legal aid program recently where an elderly client came forward. She lives in public housing with her husband, and she described 40 years of emotional abuse and financial control. And she was finally ready to try to leave, but she needed her Section 8 voucher in order to do that. And so she does not fit within the definition of domestic violence, but she did fit under the facts that we reviewed in the definition of stalking. And so we were able to make a request for a family breakup as a result and ask that she retain the assistance. It's important to note that VAWA applies both to applicants and tenants. So these are the definitions that you're also reviewing when you're considering someone's application for your housing programs. So one of the key mandates under VAWA is that you do not evict or terminate assistance on the basis that a person is a victim. And so a person cannot be evicted or have their assistance terminated based solely on the criminal activity that is on the basis of or as a direct result of their status as a survivor. And an incident of violence, and sometimes you'll see I'm using the term domestic violence, but I'm actually covering all 4 categories of violence. An incident of violence is not a serious or repeated lease violation by the victim or a good cause basis to evict them. PHAs, landlords and owners also may not deny an applicant housing on the basis or as a direct result of an applicant having been a survivor of violence. And again, this is where it's really critical for you to consider these adverse factors that really come into play at an application phase. It may be that their poor credit history, their criminal history, their poor rental history is a direct result of the abuse that they suffered. And so they require a provider inquiring about it, and if they're providing information about their status, considering that those adverse factors are related to their status. So a housing provider can still evict if they can demonstrate an actual and imminent threat to other tenants or employees at the property if the victim is not evicted. An actual and imminent threat would be consists of a physical danger that is real, and these are HUD definitions, would occur within an immediate time frame and could result in death or serious bodily injury. Factors to be considered include the duration of the risk, the nature and the severity of the potential harm, the likelihood that the harm will occur, and the length of the time before the harm would occur. HUD has defined it in this very narrow way that there's got to be a sort of concrete set of facts available and no other options to eliminate the threat. And that's one of the points that HUD really emphasizes in the final rule. Is there no other action that you could take to reduce the threat? And one of the points that HUD makes in the final rule is moving the survivor actually might eliminate the threat to others or to other tenants or to other employees. This is one of the key areas where I see providers struggle. They are seeing violence come to the property, and they're seeing a perpetrator at times continually returning to the property because the victim lives there and trying to gain access. They may perceive that the victim is consenting to access without appreciating that consent is complicated when we're talking about survivors of abuse, that we should look at it as something that they don't actually have consent over. They may be granting access to the unit because if they don't, they will be abused. If they don't, he will take the children. If they don't, he will damage the unit, and then they fear that they'll get evicted for that. So there's a number of strategic behaviors that survivors engage in that from someone from the outside not familiar with abuse may think she's just letting him back to the property and he's wreaking this havoc and I've got to take this action to evict. But it really is about making sure your staff understand the dynamics of power and control so that there's a better appreciation of those strategic behaviors that survivors deploy to keep themselves safe. It's also true that abusers will often very intentionally not be added to the lease because they know very well the dynamics and the rules of federal housing programs. So they don't want to be added so that there's this constant risk that the survivor is facing, that at any moment it will come out that there's an unauthorized occupant in their unit and the entire household is at risk of eviction. And so it is important then to really, when you think if you have to deploy actual and imminent threat, to be saying, are we thinking through what the survivors actually gone through and the strategic behaviors that they've deployed? Is this actually a threat consistent with HUD's requirements? And have we considered all other actions to reduce or eliminate the threat before we take this action? A good way to get you to this point of having that type of structure is to partner with local victim service provider organizations in your communities. They can provide training, sort of a 101 on domestic violence and sexual assault. They can also be a good place to refer survivors for support and for safety planning. Confidentiality is another key provision of VAWA. And what HUD says and what the law says is information submitted by a survivor under VAWA must be maintained in strict confidence. Housing providers cannot allow anyone administering assistance or employees to have access to confidential information unless it is explicitly authorized. And confidential information cannot be entered into any shared databases or disclosed to others, except if the disclosure is requested or consented to in writing by the survivor in a time-limited release that is for a specific purpose, or if it's required for use in an eviction or termination proceeding, or otherwise required by law. This is one of the other very, I think, common challenges with VAWA implementation, and sort of probably the number one question I get, which is, how does a survivor prove that they are covered by the Violence Against Women Act? And I think there's a lot of confusion about this, particularly if you as a housing provider were considering domestic violence prior to the 2005 reauthorization. I think what I've seen in some cases is that providers are using what they thought was the best practice prior to the reauthorization and did not appreciate that there are some pretty strict and detailed rules about proof requirements. So first, you can take the tenant at their word if they are reporting to you that they are experiencing violence. You could also, and staff, I've definitely seen this with property management staff, where they know, they are observing it. They see the black eye when someone is walking in to pay rent. I've had it where security will tell me that they will be walking the premises and they will observe the violence as it occurs. That in that way, then the provider can really be a partner and advocate to the tenant, ask them if they are experiencing the violence, and then make sure that they know about the Violence Against Women Act and what rights they have under it. If you're just taking them at their word, the best practice is to document it, but to be reminded of the confidentiality requirements, so document it in a way that will be maintained confidential and not entered into a shared database. You can also ask the tenant to prove the violence. If you do that, any request for proof must be in writing. And the tenant should have 14 business days from the written request to provide proof, and any extension granted if a tenant needs more time. Coming forward to report violence is one of the most difficult moments in a survivor's history. And it may be something that they have worked up to over years, decades, such as the example I gave at the beginning of the survivor suffering from violence for 40 years before she was ready to come forward. So being generous with extending those periods of time is really key to supporting a survivor and ensuring their safety. Here are the documentation options if you are not agreeing to just take the tenant's word that they are suffering violence. These are at the tenant's choice, and I'll explain that in more detail. Of course, there's the HUD VAWA certification form that now has been translated into multiple languages. It's on HUD's website. My understanding is the new form will be coming out sometime, potentially in the next 6 months, that you'll see that presented on HUD's website. I don't think that there should be too much change to it, however. A tenant is also free to offer police, court, or administrative records. They can be from a federal, state, tribal, territorial, or local entity or administrative record. They're also free to provide a statement from a third party, which could be a victim service provider, a medical professional, a mental health professional, or an attorney. They must be signed both by the third party and the survivor under penalty of perjury. There could also be a statement of other evidence that would be at the provider's discretion to receive. It could be evidence that they would show, such as photographs. It could be text messages of that neighbor. It could be statements from family members. So here's the HUD VAWA certification form. And as I said, there may be a new one forthcoming, but my understanding is it will largely stay the same. A couple of key things to point out. If they don't know the name of the perpetrator, or it is not safe to disclose, they can leave that blank. Why would they not know the name of the perpetrator? Unfortunately, it's quite common with victims of sexual assault, so they may not know. Why would they feel it's not safe to disclose? Sometimes perpetrators are employees of the property. Many times they are fellow tenants, or they have family who live in the development. And so that reporting of that perpetrator's name could come at great risk to them. I often get asked this question: why is the box, in your own words, briefly describe the incident, so brief? And HUD explains this in the final rule. They did that intentionally, that if you followed VAWA the first time you looked at it, I think it was a page that you could fill it out. And they said, we don't need them to be re-traumatized by telling their whole story. So that it's very intentional on HUD's part to say it's just the most salient facts that are necessary here. They also, if they don't have dates of the incident, that is also fine to leave blank. Again, thinking of the tenant who suffered domestic violence for 40 years, I'm not sure how she would answer that question. And I think that's unfortunately the experience of many survivors. So this is key, and this is where I see the most sort of mistakes happen. The survivor gets to choose the form of documentation. If you ask in writing for documentation, the only thing that they have to give back to you is that self-certification form that we just looked at. A provider cannot ask for third-party proof, such as the police or court records, or a statement from a victim service provider, unless there is conflicting evidence. And so conflicting evidence is a very narrow category. And the most typical example of that is there are two parties in the home and both are accusing the other of being the primary aggressor and committing the domestic violence. And at that point, as the housing provider, you can ask for third-party documentation. It's important, again, though, to be reminded of the fact that perpetrators can often use the criminal system to sort of get ahead of that victim and have them arrested, get an order of protection. Those plenary emergency orders of protection that are given out without notice to the opposing party can be, in some jurisdictions, easy to get. So understand in that context, when you're asking for that third-party proof, it may not be definitive. Providers cannot ask, though, beyond saying third-party proof, you can't dictate what third-party proof they provide. So I've seen many ACOPs that say you have to have a 30-day-old police report, or you've got to have an order of protection that decides who gets the housing. That, under no set of circumstances, no exception to the documentation rule, that is not allowed under VAWA. If there is this right to ask for third-party documentation because of the conflicting evidence, the housing provider can say you have to provide this information, this third-party information, within 30 days. You can also grant those extensions. It's important to be reminded of a provider's role here. And it really isn't to play detective and to figure out who was actually the victim or if there really was violence. It really is to try to, for you and your staff, think of it in this narrow way. I can accept their word. at it and document it in their file. I can ask for the VAWA certification form and give them the extensions they need. And if there's conflicting evidence, I can ask for third-party proof. But I alone am not deciding if they were actually the victim of violence. That's not my job. It's also to think about this in the context of confidentiality. I have had clients where providers did believe it was their job to figure out who, if someone actually suffered from domestic violence. And so they called other tenants and they asked if they had seen anything. And it was not only terribly traumatizing for my client, who it took everything out of her to come forward, but it also violated the law, because not only did they violate the proof requirements of VAWA, they violated the confidentiality requirements of VAWA in doing that. Emergency transfers. This is an area that we're hopeful that HUD will provide more guidance on. And, I will say, I think housing authorities are central to the success of emergency transfer plans and programs around the country. This is where the innovation really takes place. So this is where a survivor feels unsafe, or in the case of a sexual assault survivor, they're traumatized by staying in the unit. And so they can, for sexual assault, seek a transfer 90 days after the sexual assault, or in the case of domestic violence, dating violence, sexual assault, and stalking, it is a credible imminent threat. So just to be clear, sexual assault survivors have two options. They're too traumatized to stay in the unit, or there's a credible imminent threat, such as they have not caught the assailant. So survivors have this right to then apply for an emergency transfer, and HUD split it into internal transfers and external transfers. That's challenging because in small communities where there's a limited number of subsidized units, it may not be safe to move within a building or a couple of blocks. So, there's some innovation and local planning that really can make the difference. Providers have to have had in place since 2017 an emergency transfer plan that is made available to the public. A best practice would be to post it within buildings and to make sure that the tenant has a copy of it, potentially at recertification or at admission. Make sure that it's posted within the property management offices. It should be known to them that this is an option if they are unsafe. The same documentation requirements that we talked about apply to the emergency transfer program. HUD really does emphasize in this case, however, you should not be focused on proof requirements at this stage. You should be focused on ensuring that this person is safe. And so some of the suggestions and best practices that HUD states is, if you have as your policy that they have to complete the HUD VAWA certification form, and you do not accept their word, one idea would be move them first and then have them complete the self-certification form. HUD says you don't have to cover moving costs, but you're encouraged to cover moving costs. I will say we're really pushing HUD to say to housing providers that you could recoup those costs from HUD. So we're pushing that now as a way to really encourage that it's a provider's initial cost that's ultimately borne by HUD. On this issue of it often not being a safe housing option to move within a public housing development, because the stock is pretty confined within a community, or it's not safe to stay within that jurisdiction. We're really encouraging, as does HUD, the PHAs offer an admissions preference for victims of domestic violence, dating violence, sexual assault, and stalking, and then coordinate with area PHAs on that. And so a model would be when you do your emergency transfer planning, to do it with the other area PHAs and with victim service providers, so that you're really thinking through, if we all have an admissions preference and we all have the same proof requirements, and we've got victim service providers that can provide support and safety planning and training for our staff, we can really make sure that a survivor does not have to choose between their safety and their housing subsidy. As so many public housing units are moving into the rental assistance demonstration program, it's also key to include those RAD units and ensuring that those private owners that are there that have those RAD properties are working in cooperation with the PHAs. So really that model plan also includes those owners. And I've done this in Chicago. We have a model emergency transfer plan with our Region 5 office based in Chicago for the multifamily program. And we've done that with working with HUD and victim service providers and the large PBRA owners. And we got them to agree to all do an admissions preference. And now HUD will actually take those calls from survivors and advocates. And so if someone needs an emergency transfer, they call a specific person at the field office in Chicago, and then that field office person is able to identify where there may be vacant and available units and try to match the survivor with that housing provider. If we didn't do the admissions preference, as you all know, the challenge is survivors will be behind those wait lists and they're stuck and they're unsafe. And I think in many cases, they are giving up subsidized housing that they may have waited more than a decade to secure. The last idea would be to also partner with the continuums of care in your community. They may have options in terms of permanent supportive housing. They could also be an interim housing solution. So we know that there's just simply not enough housing. And so it's really a challenge to be a partner in this as a housing provider, because you can't create more housing. That's up to the Congress to issue those dollars to do it. So we appreciate the bind that you're all in. And so the COCs could be a partner here in providing interim housing to a survivor as you are waiting for a unit to open up that would provide that type of long-term subsidy that they once enjoyed. The other option that some of you may have would be the emergency housing vouchers. In the HUD operation notice for EHVs, it does say that you can use those EHVs for emergency transfers. Oh, and I guess I will say that we really pushed in VAWA 2022. We wanted a pot of VAWA vouchers so that it was a less focus on moving from a hard unit to a hard unit, but to move survivors into the voucher program, because in many ways it's the safest option in communities where it works, where there's an available supply, because they're sort of hiding in the private market. And if there are safety concerns that come up in the future, they can move again. It did not move forward. That language and appropriations line item did not get through VAWA 2022, but we anticipate there being a line item in HUD's FY24 budget for VAWA vouchers. So another sort of top issue is removing the abuser or perpetrator from the home. A housing authority or landlord may what's called bifurcate or split the lease to evict the abuser while allowing the victim to stay in the unit and on the lease and with the subsidy. And so this provides then this protection for tenants to remain in the housing after lease bifurcation. If the individual who is evicted is the sole tenant eligible to receive housing assistance, the housing provider must provide the remaining tenants 90 days or until lease expiration with a possible 60-day extension to move from the property without being evicted, or to establish eligibility for that program or another covered housing program. So again, it could be a circumstance where the victim is not known to you as a housing provider because the perpetrator did not allow them to be added to the lease and be part of the recertification process. It could also be a mixed status family, right? Where they do not have eligible immigration status under Section 214 of the Housing and Community Development Act. And the only person who did have eligible immigration status is the perpetrator, who you as the housing provider have removed from the home. That person without eligible immigration status should still have that time to see if they can become eligible, if they can move to a program that doesn't have immigration requirements, or if they can change their immigration status. And I'll talk about how that can happen in a minute. The challenge with lease bifurcations, I don't have to tell any of you if you've done it, is then the VAWA says you must follow federal, state, and local law to evict the abuser. And really what they're saying is, do your state and local laws permit single tenant evictions? Illinois does, where I'm at. A few other states do as well, maybe more than a few, but that is a challenge. In the voucher program, however, again, I'm sure all know this, but there's language in that HAP contract that says the lease automatically terminates upon termination of the HAP contract. So that may be a way to terminate that lease, terminate that HAP, move the victim to another lease, and remove the perpetrator. So family breakups are a very challenging area as well. VAWA states that a housing authority can terminate the Section 8 voucher assistance to the abuser, again, while preserving the assistance to the survivor. In the Section 8 voucher program, if a family breaks up, results from the abuse, HUD says the PHA must ensure that the victim retains assistance. So there will be, many PHAs have a family breakup process, and there will be a hearing because the perpetrator is entitled to process prior to that termination. But the obligation of the PHA is to ensure that the victim retains assistance. It's really key in thinking through your family breakup policies, the timing of that, and the safety concerns of survivors pending that. If you can, prioritize those family breakup hearings, that they're an emergency hearing of some nature, because reporting the abuse and trying to remove the perpetrator from the home, essentially to break the relationship with the perpetrator, is one of the most dangerous times in the cycle of violence. So there again, it's really key, partner with victim service providers in your area who can provide that support and expert guidance. Really ensure the timing is one that doesn't expose the survivor. I'm working with advocates now where the survivor had to wait 6 months for the family breakup hearing. And so the perpetrator was in the home with her, threatening her every day. Then when she was called to testify, the abuse only escalated when he knew that she was going to have to testify. And it required her to be in person within about 10 feet from him. And it traumatized her to the point that she almost gave up the whole thing. Like it was too much for her to go through. So really think through each step in your process. Can we do this quickly? Can we accommodate trauma and safety concerns, such as allowing them to testify telephonically or through Zoom or some sort of remote process? If we are doing anything to the perpetrator? Are we making sure that the survivor has notice, such as when that decision would come down? Are we making sure that she's also receiving notice of the decision? That may be another point where the violence could certainly escalate. And if that decision is not going in the survivor's favor, what are we doing to ensure their continued safety going forward? You know, referring them back to a victim service provider for safety planning, for example. Let me see. There you go. In deciding who gets a voucher, the housing authority can consider whether the remaining family members should get the assistance, the interest of minor children, persons with disabilities or elderly, whether family members were forced to leave the unit because of violence, whether there's a family member receiving a protection because of violence, or other factors specified by the PHA. We talked about this at the very beginning. There's the VAWA notice of occupancy rights. This is when an applicant, it should be issued when an applicant applies and is admitted to other federally assisted housing or begins to receive a voucher. And then when a tenant receives notification of eviction or termination of assistance is when they should also receive it. The housing authority has this obligation to voucher tenants, not the private landlord participating in the Section 8 program. I personally wish they would also put some onus on the private landlords, just because I see the most mistakes in terms of VAWA implementation coming with those Section 8 landlords. But part of that could also be to ensure that those landlords are trained. VAWA self-petitioners, I've sort of flagged this before. Domestic violence survivors who are married to or children of their abusers can legalize their immigration status independent of their abusers. And under a 2016 HUD memo, HUD determined that VAWA self-petitioners are an eligible immigrant category for public and assisted housing covered by Section 214 of the Housing and Community Development Act. So this would be the example where the sole person eligible at the time is the perpetrator. You, as the provider, are removing that perpetrator from the home. It is a mixed status family, and you're saying, well, there's no one here who's eligible under Section 214. I cannot continue to house them. This is really key because in many cases, they may be able to apply to be a VAWA self-petitioner, and it's at application that they are eligible under Section 214. And so ensuring that they are aware of that and they can initiate that application process, you are then allowed to continue to allow them to stay within your housing because they have met the definition of eligible immigration status. HUD implemented the VAWA final rule in November of 2016. Housing programs administered by HUD are required to follow VAWA 2013. These regulations went into effect in December of 2016. And all of the implementation notices and the emergency transfer plans and documentation were required to be out by housing providers as of December 5th of 2017. VAWA 2022, a few new things. Otherwise, most of it remains intact. The federal housing program, so HUD, the Treasury, USDA, will be creating a compliance review process. So housing providers subject to VAWA will now be subject to compliance reviews on their VAWA process. The federal programs, federal agencies have 2 years to promulgate regulations on this piece. So I don't expect us to be talking about that for a bit. Landlords are also prohibited from retaliating against tenants and applicants for asserting their rights under the Violence Against Women Act. That largely came from Section 8 landlords, housing choice voucher landlords, retaliating against tenants who are asserting their rights under VAWA. And again, I think education is key there, so that they are more partners and in this effort, and are not doing things that they shouldn't be doing. The transitional housing grants are out, or will be out shortly. That money will get out before October of 2022. As I noted, the remaining federal housing programs, including that catch-all language, is now in place. A new piece is the right to report crime and to seek emergency assistance. Under Section 603 of VAWA, it provides for the first time a protection for tenants, guests, and others, and landlords to call the police for assistance and to seek emergency assistance, and to not be penalized for being a crime victim. And we'll talk about why that language was inserted. And there's also, for the first time, training and technical assistance. So when I talk about these partnerships with victim service providers, know that there's money coming to them to help housing providers and to create these partnerships. There are state and local protections. It's really important to understand the sort of full framework of protections for survivors. So many states protect against discrimination. More than half the states now have an early termination provision, and those provisions, I don't know of any exceptions where they don't apply to the voucher program. So tenants in the voucher program can use those early lease termination provisions when they're experiencing violence, when there's a threat of violence, that they can terminate their lease early without their landlord's permission. And then the PHA is there to issue the emergency moving papers so that they can continue to use their voucher. Many states and localities also provide eviction defenses, provide a right to a lock change. Many of those lock change provisions apply to public and assisted housing programs as well. And then there are also these protections for survivors who seek police and emergency assistance. While survivors are not an explicit protected class under the Fair Housing Act, because the vast majority of survivors are women, discrimination against a survivor of violence can constitute sex discrimination. And there's a memo from HUD, somewhat dated, but still highly relevant, where they analyze claims of victims of domestic violence under the Fair Housing Act and VAWA. So some examples of this: evictions or terminations based upon the violence against survivors. An example of an intentionally discriminatory policy is one that's typically based in gender stereotypes, again, underscoring that training can overcome this sort of stereotypes that many of us hold about how survivors should act or not act. So an owner that does not rent to women with a history of domestic violence because he assumes that they'll just reconcile with their abusers. That is a pretty classic gender stereotype. Or more commonly, what I see still to this day, treating a victim differently because of their status as a survivor. So this is my case, Kathy Cleve Smilan. Miss Smilan rented an apartment with her fiance. He became abusive, and at one night, it escalated and he threatened murder-suicide. He was going to kill himself and her. She got the gun away from him. She got him to go lay down in a room. She left the apartment. She called the police. She called the property management company. Within 24 hours, she had an order of protection, and she had removed all of his belongings to storage and asked that he be removed from the lease. She did everything that she could do to exit this violent and very scary relationship. The landlord's response was, we have a strict liability policy. Whenever there's criminal activity in the property, everybody has to get evicted. We don't separate victims from perpetrators. But when we looked into it, They didn't have that policy. Their policy talked about if you were a robbery victim, if someone had broken into your unit, they had all of these things the property managers were supposed to do to help support that tenant. There was no talk about there being a threat of eviction. It was more about emotional support and other things like repairing damage that they would do for that crime victim, but not for a victim of domestic violence. There's also what's called facially neutral policies that have an adverse disparate impact, and they may also violate the Fair Housing Act. So an example would be if there is this zero tolerance for violence type of policy, that has an adverse disparate impact on survivors of violence. If you're not separating them out from that policy as either innocent third parties or crime victims. One of the most common that I see of HUD housing providers, it's their damage to the unit policies. And there is a case, the Meister case versus the Kansas City Housing Authority, where Miss Meister's husband abused her and she removed him from the voucher and from the home. But in retaliation, he came back and he damaged the unit because he believed he could get her evicted. And the housing authority said, you either make the repairs to the unit at your expense or we're terminating your voucher. She sued pro se without a lawyer, and the court thought that there was enough there for her to proceed on a Fair Housing Act claim and a VAWA claim, because the use of charging a victim for damage caused by their perpetrator really falls into a blame the victim type theory. And so those damages either needs to be sought against that perpetrator for the damage that they have caused, are borne by the property manager as it would if this person is a victim of random violence, such as a robbery or break-in. Let's talk for a minute about crime-free and nuisance property ordinances. This relates to that right to report crime provision that is new to the Violence Against Women Act. Crime-free programs and nuisance ordinances penalize landlords and tenants. They're passed by localities for police calls, nuisance, or criminal activity within a set period of time. They often impose fines, a loss of a rental license of an owner if they don't abate the nuisance, which really means evict the tenant. And nuisance activity can be anything from trash in the yard to a noise violation to a violent crime. Landlords are often pressured to evict. In this case, and if they don't cooperate, a lot of things happen to them, lots of fines, potentially even loss of their property. These types of policies and laws disproportionately harm survivors of violence who have a disproportionate need to call the police. There's a HUD guidance that came out in September of 2016 that talked about the impact of these laws on survivors of violence and how this, like, using calls to the police is a trigger to say that they're a nuisance, really silences them, jeopardizes their safety and larger community safety. What I've also found in my work is that it stops people from seeing domestic violence. And so they're just looking at, was it nuisance? And I need to get rid of the nuisance, which means I need to evict, rather than to really do what police have done over the years, is to really be involved in the domestic violence movement and really seeing abuse for what it is and trying to aid survivors. It sort of moved them in the wrong direction. So oftentimes, even with those nuisance ordinances or crime-free programs that have carve-outs that say we don't go after people experiencing domestic violence, we still see on the ground that the locality will say, well, they weren't really a domestic violence victim. It was a noise violation. It wasn't domestic violence, even though the noise is actually related directly to the domestic violence. It also really forces the survivors to suffer in silence. So they're afraid to call the police because they don't want to be threatened with eviction. It's a blunt tool for perpetrators who know if they can get somebody to call the police, they can get their victim evicted. So they can create several potential conflicts for federal housing providers, particularly with the Violence Against Women Act. It really goes against everything that VAWA was intended to do. And we often see that housing authorities and Section 8 owners are caught up in it within their communities and maybe targeted in some cases in communities. So it's just good to remember that these crime-free lease addendums that these programs often have pretty much guaranteed that they conflict with the Violence Against Women Act. There's oftentimes too that the locality is requiring you to say where the Section 8 voucher holders live in a community. That likely violates the Federal Privacy Act. So it's really important that PHAs and housing providers subject to VAWA be aware of these laws and ordinances, and know that your first and foremost obligation is to comply with the Violence Against Women Act and the Federal Fair Housing Act. Under this new right to report crime provision, as a housing provider, you and your tenants are now protected. If you need to call the police for your tenants, if your tenants need to call the police or they need to seek emergency assistance, a locality cannot use their crime-free program or nuisance ordinance in a way that would risk your status as a housing provider or their status as a tenant. That's my contact information. Emails best for me. Just looking at the, oh gosh, we ran over. So I don't know if we have questions or if we're kind of out of time. I'm going to stop sharing.
No, we're more than welcome to, if people have to get off, they are more than welcome to do so. And I understand that, but definitely, I thank you, Kate. Fantastic amount of information. Am I back to being the host? I think I am.
Yeah.
Yes. Okay. And so, yes, please, guys, if you have any questions, please do.
I have a question, if you don't mind.
Yeah.
You made me wait till we got to the end, and I just put confidentiality is the one thing that I find we have had an issue with, a situation in our housing authority where the confidentiality was taken to the extreme of, we were, still are being accused of putting out information of our family. And that has not happened, but we're accused of it. Basically, in order for them to be a resident, we try to use a, this person didn't want maintenance coming to their doors because they were afraid that maintenance would say or let somebody know where they are. That we had an out of, not state, but out of city address where all the mail would go to that particular address. And there was a package that we sent to that person. And the mail delivery is the one that put the address where she was, and someone delivered it right to her door. She's in a secure apartment building. And so we looked at that and said, what else could we do to try to make someone feel comfortable without being so accused and having to go through even HUD DC. We've been working with them to help them to know that we have not put the resident in any kind of danger at this point. But it made me realize that this is something that really could come back to bite us all. Because when you do what all you can do, but plus you cannot have systems where a person who's not a resident is listed as a resident, trying to protect the resident because we don't want to use that resident's name. So I hope you got all of what I was saying clear enough so you know what I meant.
Yeah, I mean, this is a really challenging area. And I think HUD needs to issue more guidance and give some scenarios like what you've described. I work with a group called the Confidentiality Institute, that they're really experts on confidentiality and survivors. And they've been thinking through with us, we're going to be working with HUD on a manual. And this is like part of it is some of these scenarios about like, is it safe to use the US mail? Is the survivor using a pseudonym, and who knows what pseudonym they're using? I think ultimately our recommendation is with the survivor, agree on the terms for communication. So if it's like if you are agreeing with the survivor, here's how we are going to communicate with you, and you're going to communicate with us, and it's written down, that's the best thing. And that anything that has to be released, right, through that authorization or released is very time limited and very narrow to the circumstance. But if you are using that sort of protocol and getting guidance from a local victim service provider about their safety protocols, I think that would be key. But it is tricky, especially in this age of information that's just, it's so easy to get information. So it's just even that more challenging. And that's where we're going to really push for more guidance. And I just wrote down US mail because I'm going to make sure we do that as one of our scenarios. That's a really good one.
Good. Thank you. I'll be waiting for that manual.
Okay.
Well, Kate, to the question and being able to create scenarios, as a corporate trainer and somebody who's into leadership, is there training out there that can be put together? I work with a lot of housing authorities, and it would be wonderful to be able to have some kind of training that we could put together. Is there a way that could happen?
Yeah, there's one of my she doesn't work at the National Housing Law Project. She's a consultant, Larissa Kaufman. She was at the National Alliance for Safe Housing. She is a national expert on confidentiality, and she is writing the confidentiality chapter. So I'm happy to connect you because I think, yeah, Larissa would be a great person to really get on those details because she's very much more familiar than I am with all the various databases that housing providers use. And that's another kind of trick that's a challenge that we know of.
Anybody else? Anybody from Boston? We've got Steve and we've got Brian. Any of our Boston, or I should say, sorry, New England folks?
I'm all set, thank you.
Thanks, Steve. How about you, Mr. Fisher?
I don't know why you're picking on me, but all I can think is that we could go on for another hour having conversation with you, Kate, because there's every case is different. There's so many nuances here. You're talking to a 100% sympathetic group, and we live this every day. We are sometimes witness to the abuse because we have such an intimate relationship with our families. Yeah. But at the same time, we're supposed to be a neutral arbiter on every issue. And in this case, we're being given far more latitude than we usually are. We're basically being told to be judges. And I fear that's going to get us into trouble eventually. But still in all, we're willing to take that risk because, we want to be on the side of the abused. I could think of 10 different questions to throw at you, but, time is not going to permit that. But the one issue you brought up about relocation, that's a tough one. So we get that request all the time, and we have to reason with the requester that, if we move you 2 blocks over, you're not going to get away from the problem. It's just going to reoccur, there because your location is still going to be known to your abuser. Even the issuance of a voucher is probably not going to move you out of the same city, or certainly or out of the same county. So, so we don't really have the tools to hide you the way you want to be. Oftentimes we suggest they go talk to the district attorney. Maybe the only, unfortunately, maybe the one thing that might be able to help them is some kind of like a witness relocation type of thing.
Yeah.
But so I think that's the issue that I deal with most often, that that gets to my desk. So I'm glad you brought it up. It's good to hear that you're cognizant of that dynamic. But I want to say the longer we're at this, the better school will become and how to deal with these situations. But it's been a long time now, and every case is a challenge, and unfortunately every case borders on like life-threatening. So we're trying the best we can, and hopefully organizations like yours will provide great guidance to us on how to do it better. But just because we have housing in our name, doesn't necessarily mean we're the final answer. It's just way more complicated than that.
Yeah, no, it's, I don't think anybody is satisfied with the transfer rules that are in place right now. I think it's mutual dissatisfaction because it's not understanding the market and the challenges of like your housing is concentrated typically, within a locality and within neighborhoods within a locality. These are not safe housing options. And so where I've seen success is where housing providers don't go it alone. And they say, like, let's band together and develop a community area plan. So like multiple PHAs, maybe a HUD field office helping out, COC, and victim service providers, everybody agreeing to do the same things, the admission preferences, the same policies for documentation. And ideally, if you can finance it, a VAWA coordinator who's going to be the coordinating sort of point person who will help people make the transfer moves. I think HUD is going to issue a NOFA for VAWA coordinators. And so PHAs, and they would locate them at PHAs. PHAs could apply for these VAWA coordinators. And that's sort of, it comes out of these models that a few jurisdictions have created of building these partnerships, that it makes it so much easier for housing providers because they actually can tell somebody that there's a potentially safe housing choice. It makes that community safer then, right? Because we know the violence will continue to escalate otherwise, or often does. And it, because it's in this partnership with training and support from victim service providers, you don't feel like every day you want to, you're just hitting a wall. So if we can get to that point of partnership and then really push HUD on these VAWA coordinators, that this would be a new pot of money for PHAs. I think that some of that frustration about it's just like 12 bad choices would hopefully start to go away.
Yeah, I did like that suggestion of area housing authorities banding together to create that similar policy. That creates a little better option and more distance where someone could more easily relocate to.
Yeah.
And Steve, now you know why I pick on you. You're so sharp. Anybody else?
Brian, it's Dorian. I have one quick question.
Yes, sir.
What obligation do we have, Kate, to the HCV landlords? So, for example, if someone comes to us, a HCV participant, saying, I need to transfer, I'm a victim of domestic violence, are we obligated to inform the landlord that, we're transferring this person out of the unit, or is that part of the confidentiality?
That's a great question. So I think that you do need to get the release from the tenant to tell the property owner that you're going to be issuing emergency moving papers for this victim. And you need to be telling them what you plan to do. So if it is a family breakup where the perpetrator is also on the voucher, you need to be informing them about that process. I know for some, for like the Chicago Housing Authority, who I'm most familiar with and did some work with them on their plan, they issue emergency moving papers within 48 hours of a request. They get that written release, and then they tell the property owner, and they try to help that property owner if that tenant is able to move out right away. So sometimes they'll ask that property owner, do you have another unit? And we'll move the HAP over to that unit and try to help that property owner, because they're sensitive to these property owners are also partners. If they start losing money apart this, I know that then that reduces your participation in the voucher program. So thinking creatively about how to work with them too. If you do any annual Section 8 landlord training, I just strongly encourage that you talk to them about VAWA, because again, that's where I see most of the cases, is where they just are just not aware of the law. And the head of the voucher program of CHA has done that and has some really sort of useful strategies for getting buy-in from landlords and keeping survivors safe.
Thanks, Dorian. Thank you, Kate. Anyone else? I know we've gone over the hour, but such great information. Kate, I would like to extend the invite to come back and drill down even deeper at some point into some of this once I kind of get a consensus, if you'd be willing to do so. It was really, there's so much there. And,
sure.
And Dr. Moore is giving the thumbs up, so I think she agrees. Am I correct, Dr. Moore?
Happy to. We have a very, Secretary Fudge is very committed to VAWA. So I think we're all going to be seeing a lot more from HUD on this issue. So happy to come back and think through all of that with you.
You have some trailblazers here as far as some of the expertise and folks that were on the call today. So thank you, Kate. Any other questions? If not, I want to allow Kate get back to her day and let you all get back to your day. It's slowly dissipated into a couple of us, but a really healthy conversation, a lot of good information. So I just want to thank you again, Kate.
Take care.